Hey guys, my posts are normally for all levels of knowledge, basic and intermediate HR professionals and business owners, but not today. This is not going to be an overview, and it's not a basic discussion. So today's post gets into the weeds, and it gives you a feel for advanced employment law discussion geared for lawyers at an advanced level. This is about a new April 2019 decision called Dukes versus Shelby County Board of Education, in which the 11th Circuit Court of Appeals issued an unpublished opinion that affirmed summary judgment for the employer in a Title VII case involving the convincing mosaic analysis. Now, we don't have a lot of guidance on the convincing mosaic analysis, so some of you will find this interesting. In this new case, we have Dukes, who is a bus driver, and he applied to be a transportation route supervisor, but others were selected over him. Now, Mr. Dukes claims that he was discriminated against based on race when he was not promoted. So Dukes brought his race discrimination claims under both Title VII and Section 1981. Now, because the 11th Circuit evaluates Title VII claims and Section 1981 claims under the same analytic framework, they addressed Dukes' claims with the understanding that the same analysis applies to both. Mr. Dukes claimed intentional race-based discrimination, which can be proved through circumstantial evidence. Now, in general, a plaintiff can establish intentional discrimination through circumstantial evidence in two ways. He may either satisfy the burden-shifting framework established in McDonnell-Douglas or present a convincing mosaic of circumstantial evidence that would allow a jury to infer intentional discrimination. Dukes argued that he had shown intentional discrimination through both methods, so the court addressed each in turn. Under McDonnell-Douglas, the burden-shifting framework, the plaintiff bears the initial burden of establishing a prima facie case, which creates a rebuttable presumption of discriminatory intent. And the employer then must rebut that presumption by producing evidence of a legitimate, non-discriminatory reason for its action. If the employer meets this burden of production, then the plaintiff must then establish that the employer's proffered reason is only pretext for unlawful discrimination. And the employer did not dispute that Dukes established a prima facie case of race discrimination, and Dukes did not dispute that the employer presented a legitimate non-discriminatory reason for hiring others over him. Instead, they disagreed on whether Dukes showed the employer's reasoning for hiring others was pretextual. A reason for a legitimate employment decision is not pretext unless it is shown both that the reason was false and that discrimination was the real reason. Now, when pretext turns on the relative qualifications of a plaintiff and another successful applicant, the 11th Circuit does not decide who the employer should have hired. Instead, the court looks to the qualifications of the plaintiff and the selected applicant and determined whether the difference between the two is of such weight and significance that no reasonable person in the exercise of impartial judgment could have chosen the candidate selected over the plaintiff. The court does not re-examine business judgments. The court's job is not to determine whether the employer gave an honest explanation to justify its hiring decision. Dukes argue that the employer's proffered reasons for hiring others over him were pretextual because no reasonable person could have hired them over him. This argument did not prevail. The court noted that both the selected applicants had bus driving experience, as did Mr. Dukes. The panel decided to recommend one candidate instead because he drove a variety of routes as a full-time substitute bus driver, and the panel felt that this experience made him a better candidate. In contrast, Mr. Dukes drove the same route every day in the same area when he worked for the school district, and thus he lacked experience. Although Dukes did have varied experience when he drove, he did not work in that position full-time or have the same depth of experience as the selected applicant. Similarly, the panel felt another applicant's experience as a principal and assistant principal made him a better candidate because the transportation supervisor position was a leadership position. While it's true that Mr. Dukes also had leadership experience, he never supervised other bus drivers like the chosen applicant had done in the past. And although the selected applicant had received a written reprimand, his conduct was not so egregious that a reasonable person could not have hired him over Dukes. Considering these things, the 11th Circuit Court of Appeals could not say that the chosen applicants were so unqualified that no reasonable person could have selected them over Dukes. And the 11th Circuit explained that if they did, they would be questioning the board's business judgment as to which experience to value most, which the court cannot do. Now, this follows on a prior 11th Circuit opinion when the court rejected a plaintiff's pretext argument, where her argument called into question the company's business judgment, but not the company's honesty in making hiring decisions. Now, Mr. Dukes also argued the circumstances surrounding the board's decision to hire another applicant over him showed a convincing mosaic of circumstantial evidence that would allow a jury to infer intentional discrimination. The 11th Circuit explained that in addition to the burden-shifting framework established in McDonnell-Douglas and Burdine, a plaintiff can also establish intentional discrimination by presenting a convincing mosaic of circumstantial evidence that would allow a jury to infer intentional discrimination by the decision-maker. The 11th Circuit cited a 2012 11th Circuit decision called Chapter 7 Trustee versus Gate Gourmet, Inc., in which that summary judgment is not proper if the plaintiff's circumstantial evidence is sufficient to raise a reasonable inference that the employer discriminated against him or her. In that 2011 11th Circuit case of Smith versus Lockheed Martin Corp., the record in that case contains sufficient circumstantial evidence from which a jury could infer the employer displayed a racially discriminatory animus toward a white employee by firing him. The employee in that case offered evidence that his employer used a discipline matrix that considered his white race in setting his discipline. So the employee in Smith versus Lockheed Martin also presented numerous other incidents where the discipline meted out to African American employees was considerably less severe than that to white employees. Now, that 2012 case, Chapter 7, held that the plaintiff had shown enough circumstantial evidence to survive summary judgment, where the employer's human resource director testified the plaintiff's pregnancy was a substantial or motivating factor in her termination, and her employer sent plaintiff's supervisor a letter stating that he had violated Title VII when he terminated her. So the 11th Circuit contrasted a 2014 decision it issued in Connolly versus Marta, where the plaintiff had not shown sufficient circumstantial evidence to create a reasonable inference of racial discrimination. In the Connolly case, the plaintiff was a white male who claimed he was fired because he was white. The only even remotely race-related evidence in that case was that his supervisor, who is an African-American woman, referred to herself as a racist, derogatory manner, socialized with other African-American employees. So for the 2019 case in Dukes, the question was whether Dukes had presented sufficient evidence along the lines of the 2011 and 12 cases, Smith versus Lockheed Martin and Chapter 7, to survive summary judgment. Now, Mr. Dukes claimed the following facts establish a reasonable inference of racial discrimination. 1, the specially called meeting where one selected applicant was hired despite the school board member's absence and the meeting minutes incorrectly stating that Mr. Dukes was there. 2, the board's misstatement, the applicant's qualifications and their position statement to the EEOC. And 3, the fact that no African American people are employed in the transportation department. And finally, 4, the removal of a second opening for a transportation route supervisor. Actually, there was a 5th one. Another board member's comment about receiving African American resumes. And finally, the selected applicant's hiring despite receiving a reprimand. And the 11th Circuit explained that these facts were not sufficient to present a convincing mosaic of circumstantial evidence that would allow a jury to infer the employer decided not to promote Mr. Dukes because of his race. So Dukes presented no evidence that the board's decision to call a special meeting was racially discriminatory. And while the reasons for the special meeting weren't really known, Mr. Dukes failed to point to any kind of evidence that the board intentionally excluded one of the board members. And the record in this case did not reveal why the board member wasn't even in attendance. And also, Mr. Dukes did not present any evidence that the school board lied about his attendance to conceal their discriminatory hiring. Similarly, Mr. Dukes pointed to no evidence that the selected applicant's reprimand was disregarded so that a white employee could take his spot, or that the second position was open and was removed to avoid hiring him. In fact, to the contrary, in the 2011 and 12 decisions, Smith versus Lockheed Martin, and then the Chapter 7 case, those cases, it was clear that the person's race or protected status was considered when making employment determinations, unlike this Dukes case. Now, neither was the 11th Circuit persuaded by Mr. Duke's statement that the Transportation Department employs no African American people. He failed to offer any comparative information that makes this otherwise anecdotal information significant or shows that this was a product of race discrimination. And the 11th Circuit explained that statistics without any analytical foundation are virtually meaningless. So Mr. Dukes also argued that one comment as a board member about African American resumes allowed the court to infer intentional discrimination, but the record didn't show that the board does not receive information about unsuccessful applicants. In fact, the board receives only information about the superintendent's recommended candidate, and this information is limited only to job title, location of the position, and the recommended candidate's name. So given those undisputed facts, the board member's comment did not allow the court to infer intentional discrimination by the employer. And the most compelling piece of circumstantial evidence in this case was the erroneous statement made by the school board's EEOC position statement. And the 11th Circuit explained that although it has yet to address that issue directly, the 5th Circuit Court of Appeals, in a case which Mr. Dukes relied on, has held that erroneous statements made in an EEOC position statement can be circumstantial evidence of discrimination. But even considering the erroneous EEOC statement, it alone cannot create a convincing mosaic of circumstantial evidence that would allow a reasonable jury to infer intentional discrimination. The 11th Circuit also explained that considerably more evidence demonstrating that an employer considered race is required than what Mr. Dukes had presented in this case. Hope that